All right. Bonjour, everyone. Hello. My name is Angela Riley. I am coming to you from UCLA School of Law, where we are on the unceded land of the Tongva Gabrielino people. I'm delighted to welcome you all here today. I am the director of the Native Nations Law and Policy Center, which is hosting this webinar today. And I am a professor of law and American Indian Studies here at UCLA and director of the Native Nations Law and Policy Center. I am delighted to welcome our guest speakers today to talk to us about this incredibly historic case of Brackeen, which I know many of you heard the oral arguments this week. So there's a lot to unpack and a lot to talk about here. And we're really delighted to be able to invite you for this event. I'm going to give very brief introductions of our three highly esteemed speakers today, and then turn it over to our moderator. So our speakers today, we have Maggie Blackhawk, who will actually be joining us in just a moment. Maggie Blackhawk is from the Fond du Lac Band of Lake Superior, Ojibwe. She's a professor of law at NYU, and she's the primary author of the amicus brief on behalf of the Organization of American Historians and the American Historical Association. We also have Kate Fort, who is the director of clinics at Michigan State University College of Law, and her clinic, the Indian Law Clinic, represents the intervener defendant tribes in the case. And standing in for Keith Harper, who is unable to be here today, we have my former student and Indian law attorney, Leonard Powell. Leonard is an attorney in the appellate and Supreme Court practice and Native American law practice at Jenner and Block, and he was one of the primary drafters of the tribal merit briefs in Brackeen versus Haaland. He's also a former leader of his own tribe, the Hopland Band of Pomo Indians. So with that, I will turn it over to my esteemed colleague, Professor Lauren van Schilfgaarde, who will be moderating today's event. So thank you all, Chi-miigwech, for being here, and Lauren, the floor is yours.
Thank you, Professor Riley. Gwatsi, good morning and good afternoon to everybody. Thank you so much to our panelists for joining us today. Yesterday, we heard an oral argument in Brackeen v. Haaland. For some of us, this case is the latest in a long line of big Supreme Court cases. For others, this has been a case that has been building for the last several years, if not the last several decades. And so we are really eager to debrief what we heard yesterday, as well as what we heard in the whole context of how this case is building up and potentially what we might think an opinion might reveal. But knowing that our audience is broad, some of us are steeped in these issues, some of us less so, we thought it might be helpful to give just a tiny little bit of context about where this case is coming from. And so I'd like to start with Kate Fort. If you wouldn't mind giving us this is an impossible task. I'll just concede right now, this is impossible. But maybe what ICWA is, what it stands for, and ICWA is a statute that we understand is litigated quite a bit, but not necessarily in this way. And so if you could just give us a little insight into what typical ICWA litigation looks like.
Sure, a couple caveats. One, I keep scrolling through to say hi to all the attendees. So like everyone's name that I can see is making it very hard not to call up people by name. Two, I am at home. I did just get home from DC, and the internet has been a little dicey. So Lauren is going to just pitch it to Lenny if I freeze, and I will try to reconnect. So just as a heads up. What is ICWA? How does ICWA work in 7 minutes? So obviously ICWA is a federal law that is applied primarily in state court proceedings. You have to have two things for an ICWA case. You have to have an Indian child, and you have to have a child custody proceeding. So an Indian child is a child who's a citizen of our nation, or a child who's eligible for citizenship and is the biological child of a citizen. The law uses member. Today I'm feeling very spicy and feeling the need to use citizen instead for lots of reasons after a day like yesterday. And then a child custody proceeding involves a foster care proceeding, a termination of parental rights, a pre-adoptive proceeding, or an adoptive proceeding. And I think the important piece in that is to remember that a foster care proceeding is actually far broader than what we think of as a traditional foster care proceeding. So you have 4 elements in a foster care proceeding. A child's temporarily removed from their parent, placed in the home of a foster parent, guardian, or conservator for a temporary amount of time. Parental rights are not terminated, but the child cannot be returned upon demand. So this includes third-party custody petitions, involuntary guardianships, right? This is the part, if you listen to the oral argument when Amy Comey Barrett was like, but how does active efforts happen in private? I know, was the first thing Ian said to me when we came off was, we should have talked about that. And I'm like, no, you didn't want the answer to that. That's okay. You did great. And that was what she was talking about, because ICWA applies sort of across the board. So it applies to both states and private parties. So how does litigation happen usually? Most of the time we stay in state court. And I think one of the really interesting parts of the history of ICWA is, for a while, especially right after it was passed, and you can go, Craig Dorsey did a bunch of these, and for Navajo Nation, where tribes tried to go into federal court under 1914, which says, right, that you have the ability to challenge certain provisions of ICWA in a court of competent jurisdiction. And the question was, what is that? And most of the federal courts said, well, that's a state appellate court. You can appeal ICWA, but you can't remove it to federal court. And so normally these go through state appeals, which means you get kind of the opposite of what Congress wanted, which is you do not get uniform application, generally speaking. So one of the questions we went through in preparing for oral arguments was that good cause exception. Does good cause to the placement preferences involve a best interest of the child standard? The answer, it depends. It depends what state you're in, and if that state court decides to incorporate a BIOC standard into their good cause or not. And so I think that one of the things really to remember, and then I'm going to pause because I have definitely lost track of time, is that it varies kind of wildly. And that is a real issue for tribal practitioners. That's why I started the clinic and started doing appellate work for tribes, because first of all, it's highly unlikely that a tribe is going to have an in-house counsel who's regularly doing appellate work. Appellate work is super dependent on research and writing, and you have to be able to practice in whatever state the case arises in. So it's actually pretty pricey. I've been in Colorado. We will have spent $600 in pro hoc fees to file briefs in Colorado just this semester, in the last 6 months, right? So it can get pretty pricey pretty quickly for tribes. And so that's something that one of the reasons that I started the clinic was to provide that kind of support on appeal. So tribes always had the opportunity to have their voice heard by the judges. Because the other thing to remember, which I think is really important and not remotely clear from this case, like 98% of cases that go up on appeal are brought by parents whose children have been removed or whose parental rights have been terminated. So tribes are usually not included in the appeal, and sometimes don't even know about the appeal at the Court of Appeals. We often, more than once, I've received notice of a decision at the Court of Appeals, knew the attorney at the tribe, contacted the tribe and said, did you have any indication this was going on? They hadn't received notice, they had no idea, and will come in late, like at the Supreme Court. So a lot of times if you see us kind of pop up in a state Supreme Court, it's because we didn't catch the case till it showed up in the Court of Appeals. So I think, and we can go into this a little more, and I think Lenny's going to talk about it. I think what's really important to understand about Brackeen is that, sort of contrary to the way it was framed, these were foster care cases. These three, two of them came out of a foster care system, and the third one was a safe haven drop off. And if you haven't seen the latest, I think it's the Atlantic, it's Rebecca Nagel did an article on the librettis and the story behind the Baby O case that hasn't yet been, it's the first time that's been public and I've been able to talk about it. So that's nice.
Oh, interesting. Before we get to Lenny, I wanted to just ask real quick, ICWA has gone up to the Supreme Court just a handful of times. Could you talk just briefly what those cases were?
Right, of course. It's been up twice before. In both cases, Justice Scalia voted for ICWA. So I just always like That would have been nice. So Holyfield, Mississippi Choctaw Band of Indians versus Holyfield involved the discussion of domicile in the context of a private adoption where a Choctaw couple moved off the reservation to have children, give birth. They had twins. They placed the twins with a non-Indian family, the Holyfields. It was said Hollyfield a lot at the court, which just kind of like was so frustrating yesterday. Holyfield. And the court held there that, the Native parents can't defeat tribal jurisdiction just to avoid ICWA. If their jurisdiction is on the reservation or in Indian country, the tribe has exclusive jurisdiction over the proceeding. If they are off the reservation, off of Indian country, then there is concurrent state and tribal jurisdiction. So that was Holyfield. And then much more recently, and the one that most people just looking at the list of people on here know, is the adoptive couple versus baby girl case, which also involved voluntary adoption as to mom, but an involuntary adoption as to dad, a Cherokee tribal citizen. The court, using facts that I think most of us would fundamentally dispute, held that the dad, Dustin Brown's, they found that basically they claimed he had been uninvolved and uninterested in the child, and as such sort of lost his rights to what we call the involuntary protections of the Indian Child Welfare Act, so that he was not able to receive sort of active efforts and all of the things that we would assume ICWA would kick in for. That case has actually been very narrowly applied. It doesn't affect practice very much. I would say Montana, we still see a lot of Montana putative or father cases. So where we have an established paternity, we see a lot of cases there where adoptive couple comes up. And then there was a big fight in Alaska over adoptive couple that was settled through state law, which had to do with applying adoptive couple in an involuntary context versus a voluntary proceeding. This is really the first time the court has truly heard a case where most of us who do ICWA practice, which is in the area of involuntary proceedings or our foster care child protection system.
Thanks. That was an incredible overview of ICWA in 7 minutes.
Thanks.
Welcome, Maggie. It's so great to have you. We're going to go first to Lenny, and then we'll turn it over to you, Maggie. Lenny, so here we are at the Supreme Court with a facial challenge of ICWA. How did we get here, and who are these people arguing, challenging the constitutionality of ICWA?
Thanks, Lauren. First, I'm going to admit to my detriment that I tend to call it Holyfield. So sorry, Kate. But as long as we can agree, can we say Kagama and not Kagama? And
it's Hickorea, not Hickalea or whatever they were calling it.
So this case has been around for a while. It is, as Lauren noted, it's a facial challenge. Of course, there are, in a way, underlying state court proceedings, but this case is not going to determine the outcome in any of the state proceedings that purportedly underlie this. And in fact, those state proceedings are over. So certainly this case will not determine what happens there. But the lead couple, the Brackeens, they became the foster parents to an Indian child. They wanted to adopt the child, and ICWA applied, and they didn't like that. And they brought this facial challenge in the Northern District of Texas. They found a law firm, Gibson Dunn, to represent them. Or some might say the law firm found them. I wasn't privy to what happened, but it is quite interesting how quickly they found a major law firm to take this case for them. A couple other individual sets of plaintiffs joined. The state of Texas joined, state of, I think it was Louisiana and Indiana joined as well. And they seek to strike down most of ICWA in the suit. The choice of the Northern District of Texas allowed them not only to pull a bench with primarily very conservative judges, but also to file in a division where they were, I think at that time, they were guaranteed to pull the judge that they received. Since then, I believe the venue rules have changed in that division, Fort Worth, but at the time I think they were guaranteed to get the judge that they pulled. So they were very strategic in how they framed this case, where they brought this case, who would be sort of writing the initial record, so to speak. And by bringing a facial challenge, they were able to really control the putative facts that underlie this, because they introduced evidence to support their supposed standing through their declarations. And there's not, just in this procedural posture, there's no opportunity to really delve into what actually happened in these cases in the way you could if it were actually one of those state proceedings where a final adjudication was issued and then it went to the Supreme Court. But they succeeded before the district court. It pretty much struck down everything they asked for, went to the Fifth Circuit en banc. I should note they sued federal officials and the United States. A number of tribes intervened. The intervener tribes ultimately were the Cherokee Nation, Morongo Band, Oneida Nation, Quinault Indian Nation, and Navajo Nation. And the Fifth Circuit initially upheld ICWA. I think it was completely, I haven't thought about the panel decision in over a year, but the panel decision was favorable. Then went en banc. The Fifth Circuit split pretty significantly.
For our law students, could you tell us really quick, what does en banc mean?
Yeah. So federal courts of appeal usually decide cases on by panels of 3 judges that are randomly assigned. If you as a litigant are unhappy with how the panel decision decided the case, you can petition the court to go en banc, and then all the judges who sat on the panel and all other active judges on the circuit, they will decide the case. So the Fifth Circuit issued, I think it was 325 pages of opinions. It upheld most of ICWA, but there was no one controlling majority opinion, and the court split perfectly 8-8 on a number of issues. And your point about this being law students. So a facial challenge is one where you're saying the statute is no good on its face. That's what facial means. The test, there's 2 different ways the Supreme Court has phrased the test. One of them is you've got to show it's invalid in all of its applications. But there's one that's a bit more challenger friendly. Still, though, it's a high bar. It says that you have to show that the statute lacks plainly legitimate sweep, that there's no at least core thing that the statute is doing that is clearly okay. So facial challenges are supposed to fail almost all the time. We afford Congress a presumption that it is acting constitutionally. It's a coordinate branch of government with its own constitutional duties alongside the Supreme Court. So you take common law, fed courts, these sorts of courses, and you read cases that stress how much facial challenges are supposed to be disfavored. But the challengers here, I think, are really focused on edge cases that are the fodder for as applied challenges, where you've got a specific set of facts, maybe one that the legislature never envisioned, and you're saying, well, in this particular case, we can't apply the statute in that way. But at least some of the judges on the Fifth Circuit were quite willing to entertain that very broad sort of approach to striking down the statute. I don't know how we're doing on time. If there's any, I could go briefly through sort of the court issues, if that's helpful.
You know what? We're good. We can tackle those as we sort of debrief the oral argument. So thank you. Yeah, there's clearly a lot of moving pieces, and I had totally deleted that 325-page opinion out of my mind, and now I'm like getting re-traumatized by all of that.
You're a lucky
so-
woman.
I think a lot of people, rightly so, across Indian country, quickly identified this case as scary, not just because it was an attack on ICWA, which I think is celebrated in various circles, but because it also felt like a more core attack on some of the rights of Indian country, including on sovereignty. And so, Maggie, I'm wondering if you could help situate us where this facial challenge lies in those arguments that we'll be going to. Where does this fit in Indian law and in constitutional law? Because as Kate noted, this case is very unlike other ICWA litigation in the sense that we're not arguing how ICWA operates, but whether it should operate at all.
Yeah, no, thank you so much for having me and for organizing the panel. So Brackeen, I think, is the grab bag of all Indian law cases. It is the perfect exam question, I think, for a constitutional law class, because it has everything. It has rights, it has structure, it has basically every challenge that you can have thrown into it. But I think that the big worry initially was this equal protection challenge. I'm not sure folks really took the delegation and the commandeering challenges as seriously as the question of equal protection, and then what later became a more full-throated and an even more full-throated challenge to Article I power for the Congress to be able to do this at all. But I think Indian law has, or Indian legal scholars and Native people, Native advocates have sort of seen the specter of non-Native rights claims being made for a long time. And you can see them hovering in the background of many big Indian law cases, although not addressed specifically. Even Lara itself, a case from 2004, had equal protection due process challenges hovering behind other forms of constitutional questions. And so here it was sort of a perfect storm of all of the challenges that have been hovering behind many other opinions and meeting in one big case where the justices really got to play with all of their pet problems with Indian law all in one oral argument. And so, for example, Justice Thomas's longstanding concern about congressional power, especially as an original matter in the context of Indian affairs, that was, a separately written opinion, or many separately written opinions over and over, now has taken center stage to where many of the justices are actually picking up and asking questions about congressional power over Indian affairs, its reach, its constitutional sources or extra constitutional sources, and its limits. And then also, because ICWA is particular in its structure, you see also these questions of commandeering. So for the students, whether or not the federal government has unconstitutionally told the state governments what to do. You don't see that as much in federal Indian law because it's mostly the state. The laws are building the relationship between the tribal governments and the federal government. But you see more and more the specter of states. We saw that in Castro Huerta with Justice Kavanaugh's loosely cited, I think is the generous interpretation, references to the 10th Amendment and states' rights and the equal footing doctrine. But you see these constitutional challenges bubbling up, and Brackeen, I think, allowed all of those background challenges to come to the fore all at once, especially because of the structure of ICWA involving state courts and the direction of the federal government towards state government officials. And so you get both the equal protection and the Article I question, and then questions matched with the delegation and commandeering questions. And then you also get the wonderful standing, mootness, right? And all of this wonderful set of, I mean, this is really like my con law class. I could just put Brackeen right in front of my students on the first day and the last day. But sadly, I think they may not come out the way the court does, because I think some of them may have a better understanding of federal Indian law than the court does at the moment.
Well, that means we should get right into it. So there were a lot of moving pieces in this argument, but not as many as were briefed, which I think is frequently a situation, but particularly here where Brackeen, of course, was a consolidation of a number of different cases, but they also accepted cert on a number of different questions. It was never exactly clear to me what we were even going to be talking about, so it was really interesting to see what we ended up talking about. I am open for any initial thoughts, but my take was that the overwhelming amount of time was spent talking exactly about Article I, whether or not the federal government has the plenary power to talk a little bit about this. So does anyone have any reflections on the fact that that was the dominant question, and how, where we thought this idea about the limitations on plenary power being based on land or on treaties, or having contours that I had never heard of before?
There are three, obviously. Obviously, if you have plenary power, you have very specific limits that are cabined. It means not everything, the opposite of everything. I don't know. I'm off on a tangent in my own head where I'm like, I think everyone in the audience could have answered the vaccine questions. That's all I'm going to say about that. But the Article I piece, I was not surprised, and I'm curious what Lenny and Maggie think. I wasn't surprised just because that Texas like swung for the fences on Article I in their briefing in a way that they did not below. So their merits brief to the Supreme Court was like, this now is the time we're going to go for it. And so I wasn't totally surprised that we spent so much time talking about it.
Did it stick?
Oh, stick it with the justices, do you think? I don't think so. You often, so one thing I've noticed is just the oral argument with the justices on Indian law questions, especially the first go, is really terrifying. And it looks often nothing at all like the opinion, because they're really working through their own initial questions. And so I felt like the Article I question, especially, and this isn't like throwing a, Lenny didn't pay me to say this, but Ian, I think just open and shut so much of this argument. It was sort of like I sat through hours and then there was a breath of fresh air at the end. And so in addressing that particular question, I felt like the justices really wanted to find not just the reach and limits as an academic matter. This is sort of like the Indian canons in Isleta del Sur this last term, where everyone just went, well, where are they from? And no one actually could answer the question. It felt like they were both trying to figure out the arguments that were made, which were messy by Texas. They went for the fences, but they were really sort of a disaster analytically. And so the court was trying to say, well, okay, well, if we can say this is not it, if we're going to finally draw a limit, you see this with Commerce Clause jurisprudence generally, where is our limit, you know, but we have to actually be able to give a test to be able to draw a line here. And the test that was offered was really, it wasn't satisfying, it seemed. I may be wrong, right? But it didn't seem to stick. And instead, what you had were folks needling into their own particular areas after batting around, okay, what exactly are you saying here? Why can't I make sense of what you're saying here? And how can I actually deal with this? And instead, it all trended towards equal protection, which it's sort of like Wittgenstein duck rabbit. You know, is it a limit on Article I, or is it equal protection rights limit, or is it a 10th Amendment commandeering states' rights limit? And so I felt like it didn't stick, but of course, it's really hard to predict with these folks.
I largely agree with that. You know, I think a lot of the Article 1 discussion at the beginning happened because, you know, the individual plaintiffs and especially Texas were offering these theories, and the justices were being like, what are these? What are these limits? Where are they coming from? There was still a lot of discussion of it when the United States was up. I think in part that was because the United States decided to stay in that realm. I think there was even a point where Justice Jackson asked a follow-up, and she was saying, well, but when you're talking about this sort of rational limit, you're talking about equal protection, right? You're saying that there's Article 1 authority, and then there's this equal protection, and the United States sort of pushed back and said, no, there is some sort of separate rational limit, even as applied to Article 1. So, you know, if the advocate stays there, then the questioning is more likely to stay there as well. But I think that the point sort of Maggie made about there's sort of this arbitrariness, is it's a separate 10th Amendment thing, is it this equal protection thing? If they want to say that there's some sort of limit, whether it's a really aggressive one like Indian lands, or a more modest one like rationally related to obligation to the Indians, there's more of a hook for that in equal protection than in Article 1. So I think the actual opinion, if it bought any of that logic, would focus on equal protection and not Article 1.
There was a argument relatively early on in the oral argument in which they wanted to make the case that Article 1 should be limited to commerce. And it sounded like they were trying to make an analogy to the standard commerce clause. And thereby it sounded relatively bombastic that the tribes are claiming a proprietary interest in these children, and we should be appalled by that. And it was like, yes, that is very bombastic, and that child welfare is not commerce, whereas health or education might be. And so the plenary power might extend to these areas, but it doesn't here. Maggie, I wonder if you could give us a little insight into how, if at all, the Indian Commerce Clause has been analyzed in relation to the Commerce Clause, and whether that's like an actually useful analogy, or if it really was just bombastic.
It's a live debate, interpretation of the Commerce Clause, and whether or not intratextually it should be read to have the same meaning as the word commerce otherwise in the same pieces of text. And so I think the big theorists to focus on in this area, or the two big ones, are Keelamar and Jack Balkin, who have put out the longstanding originalist theory for years and years and years that commerce at the founding reached far beyond just money changing hands, and instead covered intercourse, something that was specifically related to Indian affairs. So these arguments that Balkin and Amar made in this context had to do specifically with the Indian Commerce Clause, but they tried to then read it back into the Commerce Clause. So this is in their Commerce Clause analysis. They were facing a court on a declension march towards limiting commerce, interstate commerce in other contexts. They really wanted to open that up. And so they reached back to the Indian Commerce Clause and provided historical sources and originalist arguments around why it is that commerce reaches beyond just money changing hands. There have been other theories put forward since then by other historians that look to amalgam theories of constitutional preemption, and trying to defend the Commerce Clause, so that it's a live debate as to what exactly commerce means. So I can't say it's bombastic per se, but to read commerce what they're essentially trying to do, and what the lawyers are trying to do all over the place, is to take constitutional law in other areas and take those doctrines and read it into Indian law in a space where these doctrines have developed separately for a very long time. And what you see with Amar and Vulcan is they're trying to do the other direction. They're trying to expand out by bringing these two doctrines together rather than trying to conflate the two. So if you look at the court's Commerce Clause jurisprudence in the context of interstate commerce, they really have been needling into, okay, what's commerce? This has to be financial. It needs to be related to money at the very least. It can't be something you force people to do. They need to enter the marketplace. It can't just be about guns near schools. It can't just be about violence against women generally. You have to connect it back. There is a kind of odd exception in many instances for deep racial discrimination. However, that's largely, many argue, because those areas are just super settled. In the same way we thought Indian law was super settled in the context of plenary power. But the one interesting point, and this is something that I saw more and more in this argument, I think, than I'd seen in other oral arguments, is that the justices, I think mostly Kagan, but also Sotomayor, started pulling from the foreign affairs power. And Gorsuch started pulling from other areas of what about spending clause? What about treaty power? Let's just have a conversation about all the other ways that the Congress could do this, because what you see in other cases is a knee-jerk reaction of the court of, oh, this is Commerce Clause, Indian Commerce Clause, that's the only thing that's there. It's either Indian Commerce Clause and that power is plenary. And you start to see the court, and at least in Brackeen's oral argument, start to unpack that better, not necessarily in an originalist manner, because it doesn't need to, but to start talking about these other powers that can be used that may not have been used. There might not be a spending clause power in Indian affairs at the founding, but who cares? There's a spending clause power today. There may not have been a treaty power in Indian affairs specifically, but let's look at the treaty power today to understand the power of the federal government. That latter approach just makes more sense to me than what the lawyers were arguing, which is like it's like an antiquated view of both Indian law Commerce Clause theory as well as interstate Commerce Clause theory. But I think they were thinking, well, we'll get Justice Thomas, and maybe they will. But it didn't seem like they pulled in Justice Barrett, and they definitely didn't get Justice Gorsuch. So the originalists on the panel aren't moving the way you think they would. They're very even attenuated from the scholarly debate. Actually, it's a bit of an odd dynamic.
Interesting. Before we leave Article I, there was a question, Lenny, you had mentioned that the United States was wanted to stick to their guns on Article I regarding the separate rational limit. And if you could just contextualize us where that was.
So, sort of like where in the case.
Yeah, what exactly were they arguing?
So I don't represent the United States, and I
don't purport to know what it was.
I think that Ed Needler was focused on some language from Perrin, which, if I recall correctly, was a case where where Congress prohibited liquor sales in a ceded area, I think it was non-Indian lands outside the reservation, near the reservation, but outside of the reservation. And it prohibited, I believe, all liquor sales within that ceded area, even between non-Indians. And there's some language in that opinion that talks about sort of, well, this is an Indian area. It'd be different if it was throughout the whole state. And it's the line is something like, and it's rationally linked to the care of the Indians, this restriction. Now, I don't necessarily think it's clear that that is a restriction on Congress's power when when the law is impacting Indians themselves. I think it's possible to read that case as saying, actually, Congress's Indian affairs power even allows Congress to regulate solely non-Indian transactions that have an impact on Indians in the region.
Thank you. So as my crude way of like transitioning into the equal protection case is an area where I saw it seemed like the court was really struggling. Is this an Article I question, or is this an equal protection question? And they were this is where I heard Justice Thomas and Justice Alito make references to people that just happen to be Indian, right? Does the court or does Congress have authority over Indians who don't reside on tribal lands and, gosh forbid, aren't enrolled in their tribe, right? Are just Indians. And then this is where it seemed like there was some flowing into Rice v. Cayetano. And so the arguments seemed to get a little mushy on whether or not they were an Article I or an equal protection question. But I wonder if you have any reactions and what we might read into this happen to be Indians. Does it mean that we're likely going to see the that severed out of ICWA, the extent to which it applies to non-enrolled children, or is it something more?
It's always hard.
Lenny, go. I was like,
to happen. Arguments, as Maggie already noted, only give you so much insight into how they actually going to rule. I certainly saw a lot of concern from Justice Kavanaugh on those points, and a lot of talk about purported unilateral enrollment. I would not be surprised if Justice Alito and Justice Thomas shared those views, just because they're the sorts of ideas that I think resonate with the type of jurisprudence they've issued before, but they can be kind of hard to read in these cases because, Alito wasn't asking any questions really of the plaintiffs, and Thomas in general doesn't ask a lot of questions. But, I didn't see Roberts or Barrett picking up on the Indian child definition nearly as much as Justice Kavanaugh was. What seemed to be much more of a focus was the third adoptive placement prong for other Indian families.
Yeah, and I mean, I'll just add, this is really nice. It's really nice. And I've learned a lot doing this because this is just, I am not up in the constitutional stuff that much. I do a little, but it's a lot of practice. And I think the frustrating part for me listening, especially that automatic enrollment piece, is we have a case, right, where the 10th Circuit said, oh, Cherokee Nation can't automatically enroll children for the purposes of ICWA. And it makes me bonkers. I hate this case, And the fact that they were like, well, what about when they just reach out and enroll people automatically without any, and I'm like, I don't know a single tribe that does that. And the one tribe that did try to do it for ICWA purposes for newborn babies, right? Like just trying to get right at that eligible for membership class of newborn babies was struck down in a case I don't even like to cite very much. We did cite it. It was a big fight. I hate that case. So I just get very frustrated, and this kind of, we don't need to go there yet, but it kind of goes into, I think, Lauren, you were talking before we came on about sort of just the lack of knowledge, where you have the court making, very broad prescriptions for Indian country with very little knowledge about how Indian country works.
Well,
I don't mean to cut off.
I think this is worth the sidebar. Sorry, go ahead, Lenny.
Oh, I just want to point out the thing about very little knowledge. And like, is this ever coming up really in practice? Like, it underscores why the facial challenge is such an inappropriate vehicle for resolving this case.
I mean, I think like they literally said those words like at 5 different instances in the oral argument, like, wow, this is really hard. Then like, we don't seem to have any idea how ICWA like actually operates. Do you know how ICWA operates? Like, I don't know how it operates. It was weird.
That was brutal. That was like excruciating. in the audience to get like, well, how Comey Barrett, and someone has a comment on that. I think we might roll into commandeering, so I don't want to get ahead of ourselves, but when Comey Barrett's obsession with active efforts and how does this work? And I'm like, oh, I can tell you the case, like, and but it would have also been like too much detail, right? And this is, I have no problem saying this. I was thrilled with how Ian did, and to watch him take hours, and Lenny to watch him take hours of talking to him about incredibly complicated child welfare stuff that he has no background in, and be able to take all my like details and honestly frustration and turn it into what he turned it into. I was really thrilled. I knew he was going to be good just having worked with him, but I had no idea that we would be at that level of getting that through, because I think it would have been too much, like I would have been like, well, actually, there's a step-parent adoption case out of Washington State, and it's unreported, and it goes into great detail about what those active efforts should be in a private situation. I'm like, that's not what that justice is looking for, right? But those were brutal. Those were really hard. Sorry, that's my sidebar.
I know. Well, one more question on this sidebar, and then it's worth going back to equal protection. But there certainly was an underbelly, right? And Texas was called out for it on using this facial challenge to critique whether or not ICWA is a good idea, right? And so there was lots and lots, and it seemed like even the justices weren't sure how they wanted to handle whether or not ICWA should be a law. And so I'm curious about your reactions for when we started getting into different components of ICWA and whether or not they were legitimate constitutional questions or child welfare questions.
I know Justice Jackson really did a wonderful job of leaning in on that, as well as Gorsuch, I think, went to the mat of, he seemed a little more engaged than I expected on these matters. But Justice Jackson really drove home, they were quick to point out, no, is this a question for us? This really is about who decides. Do we get to decide? Or is this something that when Congress makes these decisions, we need to take arguments about reform to the Congress and not to this court? I did get the sense, this is a little bit of a backpedal. I got the sense that in some ways, one of the big concerns that the court had, that was many of the justices had, that was sort of hidden behind the questions, especially about equal protection, was about, well, what do we do with a federal power that means that you can take Indian people off the street and put them in boarding schools? Like, what do we do there? And to me, that was the much harder question. And I'm not sure even the conversation settled that for me, because it's sort of an area of Indian law that's unaddressed, that I don't think is best addressed through an equal protection discussion, because that's not where all of our constitutional values around these things come from. It was a little bit deeply ironic that the only justice really to go deep on the concept of American colonialism and reference it as a constitutional value was Justice Kavanaugh. And it was purely just a strange setup to his, well, we have two constitutional values here that we have to balance. He took my breath away in that one. He's like, one constitutional value is the equal protection of people. The other one is the constitutional value of the mistreatment of Native people historically and at present. And I'm sitting here going, I love this conversation. I wish this were actually what the court was engaged in here, was a broader conversation about, we have a constitutional value of American colonialism that we need to mitigate, both historically and at present. And we need to have a conversation where we balance that against other constitutional visions, values, and doctrines. That's wonderful. He went past that very quickly and very sarcastically, but it was a beautiful thing to see that unpacked. But it was a strange thing to see it unpacked for literally 30 seconds and only as a foil for someone to move in and try and undercut a statute that they didn't like for policy reasons, because you could tell very quickly that those constitutional arguments were only invoked because they didn't like the statute very much. They thought it was a bad idea.
Don't let Justice Kavanaugh trick you with his questions. I was on the Washington State Department of Licensing versus Cougar Den case, and that was maybe his first or second Indian law case, and we didn't have a sense of what his record would be like, right? DC Circuit didn't give him many opportunities to opine on these issues. And the last
He wasn't opining on the deep respect for tribal self-government.
One of the last questions he asked, maybe the last question asked of Adam Unikowski here at Jenner, who was representing Cougar Den Inc. Kavanaugh asked, "You'll suffice to say the value of the land here is incredibly significant. Like it's a huge percentage of all of Washington state, right?" And Adam said, "Oh yes, Your Honor," sat down, and we came out being like, "Oh, he gets it. Like, of course, the right that the Yakima Nation would have bargained for in exchange for all of that land would have been of significant value." And then he went and did so.
I just to be clear, I was not. He went. It was this 30-second moment where I'm just going, wait a minute, what? Wow, I didn't expect that. And then he just went, and I'm like, that's what I expected. This 30-second. Right. Did you hear that, Kate? Also, I mean, I can imagine the oxygen just leaving the room.
I was like, what are you saying? I actually had a slightly different reaction where I was like, I think he's going to equate and he did immediately go to it, right? Where he went to and so American Indians are just he went straight into race, right? And I saw that as this balance of on one hand, we have race, and on the other hand, we have Indian tribes. And how shall we? But the way you frame it is so much nicer. So I have decided I'm gonna take that as the way, because you were right. I was just like, what are you? I'm confused. So anyway. Yeah.
For being a case that potentially is going to, is threatening to undo Indian law through an equal protection argument, it felt like we had some debate around Mancari and Rice v. Cayetano, but ultimately it felt kind of light. It seems like there was some attempts that it's like, what's the scope of Mancari? What should we be doing with this? I don't think I ever heard a really satisfying answer to that, nor did I hear a really good question for how to do that. Was there any, do you all have any takeaways for how the equal protection argument came about? Or is it something maybe we don't need to worry about as much as we did going in?
I want to pause it. I'm curious what Lenny and Maggie think. I really don't love that we're in the same term as the affirmative action cases, and to me, that's where we're
not in the same. We felt like we're in the same week, right? Like Kavanaugh literally brought it up because it's on his mind.
Yeah. So I'm curious what they think. That's where I went. I don't disagree with you about sort of what I don't disagree with you. I'm tired. I'm going to let other people.
I was just a little puzzled by this because I thought there was an easy answer, that there have been, you have Croson, you have cases where Native people have been brought in under racial terms and treated as, within a racial category, and they, it falls under equal protection racial discrimination. And so the question of, can you have Native people within this list, say Indians or Native Americans as a racial category, brought in under affirmative action or brought in under admissions, that's one question. I think the harder question, of course, is one dealing with descendancy. So the University of California funding tuition for tribal members, and also I think separately for non-tribal members who are California descendants. That's a harder question, but I guess I just thought that the question they were asking was an easy question. The harder question, of course, was, you know, how far does this go? Like, where do you find the lines between Croson and Minkari? And then I thought Ian handled that really well, where he said, well, what about the DOJ? You know, what about Treasury? Let's have a conversation about, you know, what it looks like to facilitate self-government. But that was the test that he was offering about plenary power, where we're in this domain of plenary power rather than bringing it under equal protection race. And so they really were trying to find those limits. But the hard part is we're not in those limits. I think maybe the argument fell off because, like, this isn't a question about admissions. Like, this isn't the statute we're dealing with. They were trying to litigate all of Title 25 all at the same time.
Yes.
So it wasn't just a facial challenge to ICWA, it was a facial challenge to Title 25 in many ways, and that it didn't make a whole lot of sense. And I think they started to realize that of, okay, well, what about healthcare? Well, what about this? You know, what's going to go? And Gorsuch brought this up. He's like, we're going to be busy. Welcome to the new reality where the court is going to have to deal with Indian law cases that it allegedly historically hates, but all the time, which is a wonderful threat in certain ways.
Maybe the court just, you know, wants to create a lot of work for those of us who are Indian law practitioners.
Just looking out for you, Lenny. That's all they're doing. Well, the time is slipping away, and there were two other issues among many others that were on cert. One was non-delegation, which based on the fact that it was brought up 0 times, I assume the court is not actually meaningfully entertaining. But the other was commandeering. And one justice in particular seemed particularly concerned about commandeering. Any reactions to that as a legal argument and how it played out in oral argument?
Sounds like a Kate question. She had started
I'm just going to say
earlier.
that I love Justice Jackson. She is me. I wrote #hero in my notes where she's like, I don't understand commandeering here. What are we doing? Like, I don't actually believe that she doesn't understand, to be clear. I believe she fully, but she's like, where is this coming? I loved her sort of like, what is this crazy thing that seems very modern? And I can't find any old cases. And you guys keep saying that we have to have old cases to apply things like this. And yet I can't find any. I have like a whole starred paragraph from my confusion on commandeering. I thought she did a lovely job. I really loved the way she just kind of like was like, no, I don't see how you have commandeering in the area of federal Indian law, which has been kind of my fairly low level understanding of, like, if Congress has the power to do this, feels like they should be able to do this, you know, that one follows the other. I really liked that. I think, you know, obviously, and to the question in the Q&A about a hard time following Justice Barrett's questions, I think she was going straight at this question of commandeering. It wasn't clear because she didn't frame it exactly like commandeering. She framed it as what are these active efforts, and how do they work in practice, and what does it mean that Texas has to do these, and what does this look like, right? Finally, she gets Ian answering responsively some of this, so she finally gets down the path of it to, well, then how does it work? Like I said earlier, in a private, I don't think she even understood. Right, like they don't understand the distinction. So I think she said something like in a private adoption, which isn't even where it would go. And details. So I do think that was her. I know, detail. Wave your hands, child welfare. I think she really, but I do think that, to me, that was a sign that was her sort of way of getting at ICWA in a way to not kind of upend federal Indian law. I felt like someone said to me, Gorsuch was talking to her the whole time. I was taking note. I was on the other side of we were on the other side of the bench, so I didn't see them as clearly. And, you know, she did do, right? Didn't she write, Lenny, you got it, Isleta del Sur? She wrote one of those.
She wrote Dinespi.
Dinespi, thank you. I had that. She wrote Dinespi, and so I have this like sense of maybe she doesn't want to hit all this complicated stuff that we're talking about, and is like, hey, this commandeering argument seems relatively narrow, a way to get rid of an adoption law that's kind of a pain for white adoptive families. I don't know, but that's where her arguments or her questions seem to lead in that direction, I would say.
Yeah, I mean, Barrett is likely the swing, or at least has turned into the swing. She was the swing between Isleta and Castro Huerta, which I found really confusing, given the reasoning in Isleta and the reasoning in Castro Huerta. So the worry, of course, is that she swings and someone else authors the opinion, like Kavanaugh, and writes something that's more expansive. But her questions really dug in on, of course, the equal protection for Indian families placement, and then specifically the active efforts provision in commandeering for states.
Well, we have a few questions in the queue. And one of my own before we get off on this is Mr. McGill brought up several times the YRJ case. And I wonder if you have any thoughts to what the thinking was there, especially as a facial challenge. It clearly seemed as like an emotional hit on why ICWA is a bad idea. But I wonder if those landed in a way that he was hoping for.
I just came up with what it was. It was atmospheric standing. That's what it was the atmosphere of standing comes from the YRJ case, right? So just so people are aware, because this has been my pet peeve, and I have been talking to a lot of reporters about this. YRJ is the half sibling to the child who has been adopted by the Brackeens and was the subject of the original complaint. The amended complaint and the second amended complaint was all the other child who has been adopted. YRJ was born after, and there is kind of a sort of sorted state law, not on the record here, state law history of the Brackeens being extraordinarily insistent, particularly with the Texas agency. And I said this and it got picked up, but it is true that, right, the Texas agency in both of these cases did try to place these children within ICWA's placement preferences. They worked with the tribe to find these placements. The people who opposed these placements were the Brackeens, not the Texas agency. And so the Brackeens have been fighting Navajo Nation for about 4 years over the placement of this child, and she is not subject to this case. I actually don't believe that any decision that happens in this case will affect her. The case did go up on appeal. The Texas Supreme Court decided not to hear it, sent it back down. It is now, the judge was removed from like all child welfare cases in Texas. So they've gotten assigned a new judge. Yeah. And so the trial on placement, which I believe is between the Brackeens and her aunt out at Navajo, is set for December. So it is still open, but it is not clear to me at all. Well, first of all, the trial and decision will happen before this court issues any opinion. So to start with, we're in that place where we are still actively litigating ICWA cases around the country, and there will be decisions around the country up until the time this decision comes down sometime this spring and summer. But it gives them that emotional hook, and that hook of, oh, there's still a child in our lives that will be affected by this case, even if it's not honestly not true, and does not give them actual standing to bring this case. There's a lot about that piece I can go into, but I'm just going to leave it there. I think that's why they were bringing it up so much.
No, that's super helpful. Thank you. We have another great question that we just don't have time to get to, and I feel bad about whether or not international law was relied upon or referenced at all in this case. My sense was no, but if anyone has any other comments on that.
It was. Yes, it was. This was the amazing thing where, everyone I think gasped probably when this started occurring in oral argument. It wasn't used as a form of authority, but it was used as another example of federal power. And this is part of that. We're driving towards other sources of federal power through the foreign affairs power. So they reference specifically the Hague Convention.
Yes, they did.
And so you saw them drawing analogies between non-citizen or dual citizen Native children and foreign national children in other contexts, which I thought was great because I think it drove home, at least for a few of the justices, that this isn't a statute from Mars. This isn't the next race statute that's going to be applied to this racialized minority and this racialized minority. Despite the fact that, if we really were honest with ourselves, that it may be the gold standard for all sorts of communities. And I think Dorothy Roberts has drawn on ICWA in many ways, and other scholars have as well. However, to see this in the broader context of federal power and federal laws that have directed the states and state courts in family law to deal with foreign national children, just to see it as a range of statutes that have existed, that the states haven't protested, Texas hasn't protested, I think was really helpful and also really fascinating that international law is coming back in through, I think importantly, the treaty power. And you saw Gorsuch hitting that over and over again, going, well, could they just enact this through a treaty? Could they enact this through a treaty? Because if so, then why aren't we thinking about the treaty power rather than just pointing to like the Indian Commerce Clause and saying proprietary interests? The Constitution is very big. The federal power is very sprawling, so we might find something elsewhere. And I think that was a fun conversation to think about foreign affairs, because again, it's a similar doctrine of plenary power. And you saw some of the justices saying, okay, well, you think plenary power is limited in the foreign affairs context also? Is this unconstitutional also? And they wouldn't concede that, because foreign affairs is not a place where, frankly, policy-wise, the conservative talking points find limits on federal power. They want expansive federal power there and limited federal power here because they don't like the laws that are operating here, and they like the laws that are operating there, and they want more of them. And so it was a wonderful conversation that started to unpack a new way that international law could be used within the Indian law context.
Oh, thank you for that. Well, in our last few minutes, could we maybe go through where do you think we stand and what are the justices to watch here? It's knowing like no one's going to be held accountable. We're not putting money down or anything, but we seemed to have some allies based in the questions from Justice Sotomayor, from Justice Jackson, Justice Kagan, Justice Gorsuch. But from there, I think it gets a little bit murky about where justices ended up standing based on Commandeering, Article I, and the equal protection. Any thoughts?
I can go first on this one. Again, you can only predict so much. I don't know what the exact vote count will be, but I don't think they're going to want to go down the Article I road here. They want to strike parts or even all of this statute down. They have other avenues available to them that are just easier to explain, I think, as a doctrinal matter. I think they're still clearly wrong, but easier to explain as a doctrinal matter. Equal protection, I think the thing to really focus on there is the third adoptive placement preference and maybe the second prong of the Indian child definition. Barrett is gonna be important here, maybe Roberts. Anti-commandeering active efforts is the thing to watch there. It seems like Barrett really wants to write something about that. Oh, let me back up real quick and say on equal protection, standing. I think there is a real possibility that Ian convinced them, just stay out of this and this particular challenge. So Roberts, in theory, he's the sort of guy who cares about something like standing. We weren't really seeing a lot of questions from the conservative justices on those points, but they were probably pretty tired by the time Ian got up there. I mean, the chief tried to cut off Matthew McGill from having his rebuttal. And Justice Kagan asked about it, Justice Gorsuch asked about it. They're not justices who tend to ask questions unless they think there's a possibility that what the advocate will say will resonate with the swing justice, at least from my perception. Non-delegation, I agree with you, Lauren. It's just, we're going to win that one. Probably 8-1 maybe, because Thomas is just going to say there's no power for any of this, and I'm not going to join anything pro-tribal, but otherwise I think we've got that one, 8-1.
Yeah, I mean, I think I feel kind of the same I did before. I think I said someone else where like not a lot of surprises, maybe some pleasantly not as awful as I thought it was going to be, or could have been. I tend to agree with Lenny on just about all of it. I've been thinking for a while about talking to tribes about addressing. I'm gonna say this to the tribal practitioners out there. When tribes come to a case and they intervene and they say this child is an Indian child for ICWA purposes, in the face of extreme challenges. In fact, in Idaho, a colleague friend of mine was held in contempt for not releasing information about the tribal roles, for not giving information to the court and an prospective adoptive couple regarding tribal membership. I've had a case, in Ohio where they tried to filed a motion for DNA. When we've had cases where tribes come to the table, intervene, and say this child is a child for ICWA purposes, an Indian child, generally courts have been loath to look behind that decision, is what I am going to say about that. And I also think that for the third placement preference, while there are times, absolutely, particularly in Alaska where it is used, when Ian says we can't find any cases that are fights, like an adoption fight between a white non-native couple and the third preference, it's because there are no cases on that. Like we don't, and one of the things that I think is really important to think about when you're talking about the realities, they're like, how does it work on the ground? And I'd like all of you to think about, you have an Indian child, an ICWA case, the child has an Indian tribe. Who is representing this third unknown, this tribe or this parent, right? Like it just doesn't make a ton of sense when you look at how this is practiced. And so, Lenny, from your words to the chief's ear, if that's what we have to deal with, I would just say there are ways to deal with that. And that doesn't even count, like if it's commandeering, the ways to address commandeering, obviously, and just for everyone, if it's commandeering, all your state laws stand, you can pass more state laws. There are lots of opportunities there. Lauren's smiling, it's because we're working on state laws. Like there are ways to address it if we don't end up too far down that equal protection path. So
that all sounds, I have very little to add except the slight worry and the slight caveat that if Barrett is the swing and she swings her vote on a small issue, but she doesn't get to write it, that somebody might start flailing again, as you saw in Castro Huerta, which was a flail of an opinion. And so that's the only worry that I had, but it did seem like she's the swing. Lenny, did you want to say something in response?
For better or worse, I think this might look kind of like the Fifth Circuit, and we're just going to get a mess of opinions out of the court, which leaves less room for other justices to put words in her mouth. But
that would, I mean, if she wrote separately, that'd be great, but she doesn't seem to. I mean, I'd have to look back. It doesn't. It's not like she's explaining her or swinging at this stage. But it would be great to have it more fractured, because then it wouldn't, you know. The hard part though is that it's not a whole lot of direction for Congress to have a fractured opinion like that, and it starts to clog the wheels of legislative action on these issues, especially if the role of Congress. So again, getting back to who decides, the role of Congress isn't clear, that it is in the driver's seat on these issues. If the court starts backpedaling on those things or fractures on those issues, Congress doesn't need a lot to be more dysfunctional than it already is. And so it gives it an excuse to just not to stall as it does in many other areas.
Well, thank you all so much for your insight. I can tell you, I personally have appreciated it. This was a big case with a big, long oral argument with lots of different pieces. And so I certainly benefited from all of your insight. Thank you to all of our attendees for sticking with us, including 5 minutes over. Like other UCLA Native Nations webinars, this is being recorded and it's going to be posted on our webpage. In addition to this, we've also included links to the briefs as well as some of the news media about this case if you're interested in learning more. Otherwise, I'd just like to extend our sincere gratitude for all of our panelists. Thank you so much. All right, well,
Thank you.
that's it. Take care.